Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيرا لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجانا، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. هل لديك مشاكل في قضايا الضمان الاجتماعي أو قانون إصابات العمل؟ المحامي باتريك هوران من مكاتب المحامية جومانا كيروز يضع خبرة 28 عاما في قضايا الضمان الاجتماعي وإصابات ضمن العمل في خدمتكم. الاستشارات مجانية. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645. يتحدثون لغتكم العربية والكلدانية 248-557-3645. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. طابت أوقاتكم بالخير. أهلا بكم أحبائي المستمعين في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز على الهواء مباشرة. أرقام الهواتف في الاستوديو 313-769-6666 ودائما على الواتساب برسائلكم الصوتية أو النصية، والرقم هو 313-327-7074. بإمكانكم الحصول على استشارات مجانية في القضايا التي يتعامل معها مكتب المحامية جومانا كيروز، وهي قضايا الإصابات الشخصية من ضمنها حوادث السيارات، إصابات العمل، الأخطاء الطبية، قضايا الهجرة والتجنس، قضايا الإفلاس والضمان الاجتماعي وقوانين العائلة. 248-557-3645 248-557-3645. هذه الحلقات حلقات برنامج يور رايتس يعاد بثها مرة أخرى على موقع اليوتيوب. كل ما عليكم هو زيارة قناة جومانا كيروز على اليوتيوب والمشاركة فيها والضغط على زر الجرس ليصلكم كل ما هو جديد. نتمنى لكم متابعة طيبة. جومانا مساء الخير ورحب بك في برنامج يور رايتس.
مساء الخير رامي، يعطيك ألف عافية. كيفك اليوم؟
مساء النور، الحمد لله. نسأل عنك إن شاء الله بخير.
كثر خير الله. مساء الخير لكل المستمعين. نحن اليوم نهار الخميس ومستضيفين المحامي باتريك هوران، اختصاصي في قضايا الضمان الاجتماعي والإصابات ضمن العمل، يعني بسموها بالإنجليزي Social Security and Workman's Compensation. اليوم رامي رح نكمل نحكي عن الإصابات ضمن العمل. عم يجينا كتير اتصالات عن هذا الموضوع، عم بيصير في إصابات وعم نحكي عن الموضوع، وبالإضافة في عنده نيو announcement لأنه ظاهر أنه الوركمنز كومبنسيشن بيرو رح يرجع يفتح قريبا. رح أطلب منه أنه هو يبلغنا عن هذا الموضوع. Good afternoon, Attorney Patrick Horan. How are you today?
Good afternoon, Joumana. I'm doing great. How about you?
Very good, very good. Are you calling us from your boat?
No, it's a little chilly today, so I'm in the office.
Okay, fine. I feel better now. Patrick, you told me as we were preparing for the show that there is a reopening in the world of workman's compensation. Can you share with the listeners what is reopening in workman's compensation and when?
So obviously we've all been through a lot in the last year, and everything's been changed. Everything's been remote. We've been doing hearings. We've been doing discussions with the judge about our cases. We've been doing all that on the telephone. And as of July 12th, the Workers' Compensation Agency, or what you would think of as court, is open for business. And that means that just like the old days, the judges will be there We'll be able to show up and see the defense attorneys face to face, discuss the cases, have trials if we can't resolve a case by way of a settlement, and it'll be fairly normal.
So how do you feel about that yourself as a practicing attorney? Are you excited about that? Are you happy about that? Or is this going to be, again, driving to court and wasting time, waiting in court and wasting time, driving back from court and wasting time?
Well, it's true. There's give and takes in this, and I have mixed feelings. Now, I will have to learn to tie a tie again. It's been a minute since I've tied a tie, but I think that it is very helpful to have face-to-face interaction with your opponents. And in this particular area of practice in workers' compensation, it's not unusual to have really deep and lasting friendships, even with attorneys that are on the other side. And to have those kind of relationships, I think, helps in the resolution of cases. And having a face-to-face interaction, I think, is only going to be good for the case.
You know, Patrick, it's very interesting you talk about having friendly relationships with lawyers on the other side, because they're pretty much the same lawyers that you see on your cases, that you've seen on your cases. Over the years, I have heard clients say, think of that as negative. Think that if their lawyer is friendly with the other side, that means, or that may mean, that their lawyer is not doing everything to fight for them, that they are giving in to the other side. So they mistake friendliness, and we're talking generally, of course, but they mistake friendliness with the other side with selling their case short, so to speak. Can you comment on that?
Yeah, I think what you're talking about really goes to the heart of professionalism. It would be completely unprofessional not to represent your client to the best of your abilities and to give them a vigorous prosecution of their case. But that doesn't mean that you have to be a jerk when you walk out of the courtroom with anybody, let alone with the other attorney.
So are you able to be friendly with defense lawyers and still be the best advocate for your client? Do you sincerely believe that?
Absolutely. I've done that for 30 years now, and I find it helps because I can get an insight as to how the other side thinks, and what they're looking for when they're defending a case.
So sometimes that relationship and that relationship of mutual trust and respect allows you to gain insights into your client's case that you may not be able to gain so quickly, at least.
Right. And we're able to, we can bounce theories or questions about the law off of each other, over a beer without divulging any of the facts about our particular client and ruining that relationship.
Sure. And you can agree to disagree, and you can, hold to your guns if the defense lawyer with whom you are friendly, does not see things your way. You can do both at the same time.
Absolutely. And I think it's a complete positive to have that situation. I'm sure you've seen over the years attorneys who don't act that way, and they don't get very far in this business if they're not affable outside of the courtroom.
I agree with you wholeheartedly. I think you can do both. I think you can be, of course, civil, but also quite the advocate for your client while being friendly and respectful and reliable and trustworthy with the other side. We have a few lawyers in the world of car accidents on the defense side that all of us plaintiffs' attorneys know about. We know they cannot be trusted. We know their word is not their bond. We know that if they commit to something, we like to see it in writing. Those who are unreasonably difficult, we know about them, and they don't get very far. You are absolutely right. We kind of know the difference between being friendly with the other side and how useful it is, both ways, by the way, and at the same time, representing your client to the best of your ability with the best advocacy and getting them the best settlement. I think we can do both at the same time. Before we file lawsuits in car accidents, we deal with a lot of adjusters, and we know so many of these adjusters. We know their style, we know how they think, we know what they're looking for, and we have very good courteous relationships with them. And sometimes they give us tips. They tell us things we're not supposed to know. We ask for their help. When a case is under investigation, they often, but not always, tell us, what's the reason. And at the same time, we hold firm and we request our clients' benefits and we insist on them and we have an intellectual discussion with them. And 8 times out of 10, it unlocks the case and you start getting payment. Sometimes it takes a minute, but you start getting payment if you hold your guns. And 2 or 3 times out of 10 it doesn't happen and you file a lawsuit. One of the many reasons why you file a lawsuit. So I've seen it, I've practiced this, but where you can do both. But
Right.
you don't.
And the old saying is that the world is round, and if you're a jerk to people all day long, one of those days they're going to need a favor, and then when the world comes around and they need that favor, they're not going to get it.
I agree with you wholeheartedly. You will remember how they were to you last time, and you will be less likely. I mean, it's pure psychology.
Absolutely.
I agree. Thank you very much for those insights, and it's exciting that the Workmen's Compensation Tribunal will reopen. Now, you did say that in workmen's compensation, it seems to me that generally speaking, workmen's compensation cases take less time from beginning to end than in car accidents, because in car accidents, you have to be injured, you have to treat, you have to request benefits, you have to be denied benefits before you even have a reason to file a lawsuit. Otherwise, your lawsuit is premature and maybe frivolous. And we file a lawsuit at the anniversary of the 1 year for various reasons. And then you push forward a year and a half from when you file, because that's how long a car accident in general takes. Some take a little bit under a year, some take a little bit over a year, some take up to a year and a half from when you file a lawsuit. If you file the lawsuit within a year from the accident, but almost before the 1 year anniversary, you're already 1 year back, you're about a year and a half moving forward. So sometimes cases take up to 2.5 years from the date of the accident, a good 2 years for sure from the date of the accident. It seems to me that workmen's compensation cases take a little bit less time. Am I right?
Yeah, a 2-year-old workers' compensation case is pretty darn old. There's got to be some kind of problem that made a case drag out that long. It does happen, but the vast majority of workers' compensation cases are resolved certainly within a year.
Okay. So when you say you're excited about the court reopening and, seeing your colleagues and moving files along, because sitting face to face across from a lawyer sometimes is more conducive to moving things along than over the phone. The workmen's compensation courts issue what's called control dates, meaning these are dates where the lawyers, but not their clients, the lawyers, but not the injured worker and not the adjuster for the workmen's compensation, the lawyers go to court and talk to the judge about why is this case not done yet and what can the judge do to move both parties toward a resolution. You said to me that sometimes clients get upset because they call you and they say, well, where is my file and where I'm at and how come I haven't received any date for court and how come, are you doing anything on my file? And because to them, unlike in a car accident, where the judge issues a scheduling order and some of it involves the injured car accident victim, requires their presence, like, say, a settlement conference and so forth. In workmen's compensation, those dates where you go to court on behalf of your client, they are dates that are shared only with you as the lawyer. The court does not send notice of these control dates to the injured worker, correct?
That's absolutely right. And there's no depositions that are taken of the injured worker, unlike an accident victim in a car accident or other circuit court case.
Sure.
So there's going to be oftentimes literally one notice that they'll get from the workers' compensation agency when I first filed the petition on their behalf or the application. And after that, there won't be any formal correspondence from the agency to the client unless or until the case notice is up for trial.
So that is why a lot of clients who, were injured on the job, they get frustrated and they call their lawyers saying, look, are you even doing anything on my file? Because I haven't heard from anyone. I haven't heard from the court. I haven't heard from you in a little while. So are you even working? But the truth is that the court sends to you as the lawyer these control dates. And you said every case, they're very aggressive, by the way. I understand now why cases in workman's comp take less time than cases in car accidents, because you told me that the courts will send you as the lawyer anywhere from as little as 4 control dates to 10 control dates. So these are like 4 to 10 attempts on the part of the judge to put the pressure on you and on the defense lawyer representing the workman's compensation insurance company to move the file along.
Right. It's like a meal going through the body of a snake from the time that we file the application for hearing to the resolution of the case, one way or the other. Either the case is tried or it's settled at the end.
Okay. So so you get the control dates, your client does not need to attend, right?
Right. From the very beginning, the first notice that they get in the mail, I bet if I had a nickel for every time a client has called me and said, do I have to show up for this? And right on that notice, it says, if you have an attorney, you do not need to show up. That first hearing is called a pretrial hearing. And all that day is the judge writes the first control date next to the name of the injured worker on a list and puts it outside his or her door. So,
and the injured worker does not need to show up for that either.
Absolutely not. No. And we pick up that date. By that time, we've gotten an appearance from the defense attorney and their insurance company. We've started to send medical records and request records from the injured worker's doctor. The other side, the defendant, most likely will be scheduling the injured worker for a medical exam and subpoenaing medical records from the treating doctors as well.
By the way, just like in a car accident, where if your insurance company sends you to their doctor, you are required to cooperate. It's in everybody's car accident policy. It's also in everybody's workman's compensation policy through the employer that if they request that you submit to an exam with a doctor of the insurance company's choosing, you must submit to that.
That's right. And if you don't show up to a workers' compensation medical exam, the other side will file a motion to suspend your benefits. So even if you end up winning the case in the future, you could have your benefits stopped for that period of time that you refuse to be examined.
Until you go back.
Exactly.
Right. Now, it's okay sometimes to get a medical exam date that's not convenient for you. Then you call your lawyer and, your lawyer will work on getting you another date. So it's okay to postpone it for a legitimate reason, but ultimately you must submit to a medical exam.
Right. And they have to properly notice it up and make sure that they paid mileage to and from the exam as well. But yeah, definitely during the pandemic, I had several clients who had a family member test positive for COVID, and obviously they had to be quarantined and couldn't show up for their medical exam. And we just informed the other side of that, and they rescheduled it, and there was no reason to have a motion or fight about that.
Now, with car accidents, almost 100% of injured clients sooner or later are required to submit to a medical exam or more. Is that the case also in workman's compensation?
Absolutely. The Workers' Compensation Act provides for medical exams from time to time, and that sometimes can become an issue of whether they're scheduling too many exams. I feel like it's not fair if an insurance company starts doctor shopping and looking for a doctor that'll see things their way. I feel like they should stick with the same doctor that examined my client the first time.
In car accidents, if an injured person has seen an orthopedic surgeon and a neurologist and a physical medicine and rehab, for that person to be properly cut off, the insurance company has to send them to an insurance doctor specializing in orthopedic surgery. then another doctor specializing in neurology, and then another doctor specializing in physical medicine and rehab. Is it the case also in workman's compensation?
There's not a formal rule to that regard, Joumana, but I've definitely cross-examined plenty of doctors who were sent to examine my client outside of their specialty, and it's a delight when you cross-examine a doctor who is not familiar with backs to point out that their entire specialty has been as a hand surgeon, but this insurance company asked them to examine my client's back.
Understood. You know that the third of the last changes in auto law is about to take place in July, in about, 5 weeks. And the rates for treaters in car accidents is going to really go down. It's going to be 200% of the Medicare rate very quickly. How does that compare with the workman's compensation rate? How does the workman compensation rate compare with the Medicare rate?
You know, workers' compensation for years and years and years has had cost containment guidelines, which is what is now being enforced on providers in auto cases. I can't speak to how they compare to Medicaid or Medicare. They're definitely much lower than what providers were getting for auto cases.
Right.
It's not unusual for me to see, for instance, a physical therapy bill to be less than half of what the provider had billed.
Right. Okay, no problem. We will look into that, and when you find out, what's the percentage. I'd like to see how that compares with the new rates. But no worries. Let's take a quick break, and after we return, let's talk about, practically speaking, when somebody gets injured on the job. Practically speaking, what is step number 1? What is step number 2? What is step number 3? What is step number 4? And equally important, what if somebody tells their employer about an injury and the employer refuses to turn this over to their workman's compensation insurance? How is the employee to even know what insurance does the employer have, and what's the name of the insurance company, and how do they call the insurance company to open a claim? So with the rest of the show, we want to talk about practical steps when someone gets injured on the job.
هل لديك مشاكل في قضايا الضمان الاجتماعي أو قانون إصابات العمل؟ المحامي باتريك هوران من مكاتب المحامية جومانا كيروز يضع خبرة 28 عاماً في قضايا الضمان الاجتماعي وإصابات ضمن العمل في خدمتكم. الاستشارات مجانية. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645. يتحدثون لغتكم العربية والكلدانية 248-557-3645. قد يحاول بعض المصابين في حوادث السيارات إدارة قضاياهم توفيراً لأتعاب المحامين، والآن مكتب المحامية جومانا كيروز بإمكانه المساعدة من خلال إشرافه على سير القضية في جزئها الأول المتعلق بتعويضات الراتب والخدمات المنزلية، وتقوم بإرشادك في كيفية إدارة ملفك مجاناً، بينما سيتولى المكتب مهمة الدفاع عن قضيتك في جزئها الثاني المتعلق برفع دعوى عن عطل وضرر. للمزيد من المعلومات اتصلوا بمكتب المحامية جومانا كيروز والاستشارات مجانية 248-557-3645. Your Rights مع المحامية جومانا كيروز. هذه عودة إلى برنامج Your Rights مع المحامية جومانا كيروز على الهواء مباشرة. أرقام الهواتف في الاستوديو 313-769-6666 519-256-1023. جومانا رجع لك مرة أخرى.
شكرا جزيلا رامي. عم نحكي مع المحامي باتريك هوران مثل تقريبا كل نهار خميس عن موضوع الإصابات ضمن العمل. بدنا ننتقل عمليا رامي، وقت الإنسان بيصير عنده إصابة ضمن العمل، شو الستبس، شو بيقولوا ستبس يعني
خطوات.
نعم،
خطوات.
الخطوات.
نعم.
شكرا. شو الخطوات أو الإجراءات اللي لازم يعملها؟ لأنه كتير أوقات رامي الموظف ما بيعرف مين الانشورنس كومباني تبع رب العمل أصلا، يعني كيف بده يتواصل معهم، كيف بده يفتح كليم معهم. طب بركي الامبلوير ما عطاهم لسبب أو لآخر ما بده يوفر على حاله، ما بده يعمل كليم مع الوركمنز كامب لحتى ما يعلى البريميوم عليه. هذا الشخص عمليا شو بيعمل؟ تعرض لإصابة ورب العمل ما عم بي is not cooperating with him لحتى يقدر يعمل كليم. رح نحكي اليوم شوي عمليا الإنسان اللي بيتعرض لإصابة ضمن العمل شو لازم يعمل. Patrick, we want to talk practically right now. Let's assume that somebody gets injured on the job. You know, employees don't know, one, if their employer has purchased workman's compensation, despite the fact that maybe they should because the law requires them to. Two, if they have purchased, it's not public knowledge in an office who is that workman's compensation insurance company and how do we get to them and what the policy number is. So if someone approaches their employer about an injury on the job and the employer does not cooperate and share with the employee who the workman's compensation insurance is, how will this employee reach that workman's compensation? And before you answer that question, can we remind the listeners about who's required as an employer to purchase workman's compensation?
Well, in an earlier show, we went through that, and it had to do with having, I believe, more than 2 employees. Or 3 employees part-time. There's a specific rule that honestly I don't have to pay attention to because I'm not representing the employer. Okay.
Sure. I just wanted the employers out there to hear that it's a very specific rule that anybody can find it on the internet. It's very clear. It's black and white. If you have more than 2 full-time employees for a number of weeks, if you've had them, then you should be buying workman's compensation for your employees. Or if you've had 3 part-time, a number of weeks for the previous whatever, then you should buy workman's compensation. The point we want to bring across is you don't have to be Ford and you don't have to be Coca-Cola to buy workman's
That's
compensation.
absolutely right.
You can be a very, 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 very small office consisting of only 2 or 3 people and still be required to buy workman's compensation. And the other thing we want to add, it is in the best interest of every employer who is required by law to buy workman's compensation to buy it. And here is why. Because workman's compensation insurance, and I don't mean to take this over, I apologize, but I feel strongly about this. Workman's, and a lot of employers are not buying workman's compensation because they want to save. And by the way, workman's compensation generally is not expensive, workman's compensation insurance. But at any rate, those employers who are required by law to buy workman's compensation insurance and have not, they are exposing themselves to being sued personally by the injured worker. So buying workman's compensation insurance is immunity for the employer. It is a shield for the employer. If you have to buy workman's compensation insurance as an employer and you bought it, then if God forbid one of your workers gets injured, your worker cannot sue you as the employer personally. Your worker cannot go after your money as the employer. But if you did not do the right thing and you did not buy workman's compensation insurance as an employer, then that immunity comes off and that worker can file a general negligence claim against you and go after you for the full extent, even including their pain and suffering. Care to comment on that?
No, that's absolutely right. And we've talked before about workers' comp being a no-fault system, that you can get benefits as an injured worker, even if it's your fault if you get hurt. But very often it's the employer's fault that you got hurt, and their negligence doesn't matter. But if they don't have workers' comp, you can take them into circuit court in a negligence case and get all kinds of tort benefits that you can't get in workers' comp.
And I wish that, every person listening heeds that out. Number one, you don't have to be big to be required to carry workman's compensation. Number two, it is in your best interest as an employer to carry workman's compensation because then you have clear immunity. Should your worker be injured and should it be your fault or the fault of the workplace, which happens often enough. I'm just going to share this very important point in Arabic because it is important. رامي، أول نقطة بدنا نوصلها وحكينا عنها بالماضي but it bears repeating مثل ما بيقولوا. أول نقطة بدنا نوصلها إنه منك مش ضروري تكون كرب عمل، رب عمل كبير عندك 10 و20 و30 و50 موظف لحتى القانون يجبرك ويفرض عليك إنك تشتري workman's compensation. الworkman's compensation insurance هي لأي رب عمل عنده 2 full-time employees لأسابيع معينة تقريبا 26 weeks if I remember أو 3 part-time employees كمان لبعض الأسابيع. So أول نقطة بدنا نوصلها مش you don't have to be a very big employer لحتى القانون يفرض عليك تشتري workman's compensation لحماية موظفينك. تاني نقطة بدنا نوصلها لا يحمي حاله أي رب عمل مطلوب منه يشتري workman's compensation لأنه عنده أكثر من موظفين full time أو 3 part time. من المستحسن إنه يشتري لأنه هيدي الانشورنس هي كمان حصانة لرب العمل. شو قصدي؟ إذا شاري workman's compensation وصار في إصابة حتى لو الإصابة سببها رب العمل، المصاب ما بيقدر يطال رب العمل. في workman's compensation insurance هي اللي بتغطي، وإنما هيدي الحصانة بتنرفع عن رب العمل. إذا مش شاري workman's compensation insurance وكان مفروض يشتريها، ساعتها المصاب بيقدر يقيم دعوة خاصة ضد رب العمل. بالworkman's compensation ما فيك تقيم دعوة ضد رب عمل، مشان هيك عندك workman's compensation insurance. إذا هذا الرب العمل ما شاري workman's compensation insurance، ساعتها المصاب بيقدر يقيم دعوة خاصة ضد رب العمل in a court of law وبيقدر يطال مش بس طبابته وراتبه، بس كمان بحق له يعمل كيس ضد رب العمل عطل وضرر. So workman's compensation insurance هي حصانة لرب العمل وهي لحماية الموظفين. وبفتكر إجينا سؤال رامي.
نعم جمانة، يحكي على يعني نفس النقطة اللي ذكرتيها اللي تنطبق على السيلف امبلوي.
No. إذا كان الإنسان self employed بس ما عنده موظفين منه رب عمل، هيدا القوانين كلها اللي عم نحكيها ما بتطبق. Attorney Patrick Horan, does the immunity that is afforded to an employer because they did the right thing and bought workman's compensation, does that apply to someone who is an independent contractor working with that employer? No.
No.
So if an independent contractor or self-employed person provides a job for an employer, remember, they're not an employee, they're just providing a job, they get injured, is the employer at all liable? Is the employer's workman's compensation insurance at all, does it at all come into play?
Not if they're not an employee. And ordinarily, as an employer, when you purchase insurance, you have to enumerate the number of employees and what kind of jobs they do. So if you hire an independent contractor who's not considered an employee, and we've gone through this in earlier shows, what those steps or what those tests are to determine if they're an employee. But if you hire an independent contractor and that person gets injured through your negligence, you could be sued, same as any other relationship.
So if an independent contractor who is doing a job gets injured because of the owner's mistake, or let's say an independent contractor comes to your home and does a job, can the independent contractor sue you? If you are a homeowner, maybe it's your homeowner's insurance. And if you are an employer, let's say somebody working at a business building doing some work, can they sue if the negligence is the negligence of the business owner? Can they sue the business owner?
Absolutely. Happens all the time.
However, a smart business owner will make sure that an independent contractor is insured.
Right. Or they'll be covered by their own business insurance as opposed
Correct.
to workers' comp insurance.
That's what I mean. That's what I mean. And quite often, independent contractors will tell you before they provide a job for you, we are insured, licensed, and bonded. And these are protections for the business owner who wants an independent contractor to come to the job, to do the job. Going back to what if an employee gets injured on the job and the employer does not want to cooperate? How will the employee even know who is, number one, if the employer has workman's comp, and number two, who is that, and number three, what is that policy? Because without any of that, a claim will not be opened, and this injured worker cannot start treatment and seek 70% or so of his wages.
Right, and this happens fairly often. I think because a lot of employers are under the impression, whether it's true or not, that their premiums will go up if they make a claim with their workers' comp insurance. So they oftentimes are loath to make that claim. And when the injured worker contacts them and says, I got hurt, they may attempt to pay the person under the table or just placate them and tell them that they'll take care of it, but not make the claim with their insurance company. And I've got a question for you, Joumana. If you're an injured worker, when should you make the claim after you get hurt?
Immediately,
Exactly.
as it is unfolding.
Exactly. So the biggest thing that will raise a red flag to an insurance adjuster is if somebody gets hurt on a Thursday and doesn't tell their employer about it until the following Monday. They will say, well, hold on. What was this person doing over the next 3 days that we didn't have him on the job and he might have gotten hurt at home? So it's always important to tell your supervisor immediately when you do get hurt.
So dealing with insurance companies is hard enough as it is without adding wrinkles of your own choosing. One of the things a workman's compensation insurance and an employer will be looking at is, well, wait, did this arise out of the job? Does this happen on the job? And when you delay, you are inviting these questions, and you are inviting, wasting time and having an adjuster even take more time to look into whether or not this happened on the weekend, this happened on the job, did anybody see it, did you talk to anybody about it, and so forth and so on. So when you are injured, you should immediately report it to your immediate supervisor or HR or something like that, correct?
That's exactly right. And then the next step would be a good employer will make a claim with their insurance company, and the injured worker will get a claim number, just like you do when you smash your car. You get a claim number from your car insurance. You'll get a claim number to give to the company clinic for the first 28 days and to your own doctor after that for medical treatment related to your work injury.
And what if your employer does not cooperate? What do you do now?
Well, the next thing you need to do is get the state of Michigan involved. And either you call an attorney and we prepare a form and file it with Lansing to start a lawsuit against that employer, or you call Lansing directly and the workers' compensation agency will notify the employer that the claim has been made.
Okay, so if an employer does not cooperate and share the information with the injured worker, either personally or through an attorney, can direct the state, that can contact the state of Michigan Workmen's Compensation Department and report that this employer is not sharing. There is a form to fill out. You call it an application for hearing, and the department in Lansing will match that application for hearing about that employer to the insurance they have on file, and they will then serve a copy of that application to the employer, to her or his insurance company, to the injured worker, and to her or his attorney.
That's right. And it'll go out as a notice of hearing for that first pretrial hearing that we mentioned a couple minutes ago.
I lost you, Pat.
I said that once they file that with Lansing, the notice of hearing is generated for the first pretrial hearing, which we talked about a minute ago.
Okay, so the bottom line is an employer can either cooperate or will be forced to cooperate when you contact the state of Michigan, and they will match the name of that business with the insurance company on file, because every employer is required to notify the state of their work compensation insurance.
Absolutely. And when we've talked before about there's a wide range of relationships between employees and employers. And a lot of times in this situation, the employer is friends with their worker, feels for their worker, wants to do the right thing by them, and the insurance company will aggressively defend the case, perhaps more so than the actual employer would have.
So the fact that the employer is on board and agrees with the worker that he likes and agrees that the injury happened on the job and that the injured worker cannot return to his employment, the insurance may still not be on board. They need to do, the workman's compensation insurance adjuster still needs to do their own investigation.
That's exactly right.
Okay, so you need the employer on board, and for things to move quickly, you need to employer on board, give you the information, and then the adjuster needs to do investigation. Now, in car accidents, sometimes investigations by adjusters can take as little as 3 months, and as long as we have to file a lawsuit because it is 1 year, but it's not unheard of cases in car accidents where the investigation is taking 5-6 months, and we know everything is right and by the book, so we know we'll be okay, and we hope that the claim will be open after we give enough time for the adjuster. And sometimes delays happen for a number of reasons. Adjusters are overworked, there aren't enough adjusters, they're waiting on medical records from a doctor who isn't sending them. They're waiting on outside. They're waiting on a wage, salary, and benefits verification form from an employer who claims did not receive it, did not send it back. So in car accidents, investigations can take as little as 3 months from when a client comes to us to as long as 5-6 months. We just had a couple of claims in our office. Clients we feel very strongly about, beautiful clients, injured, everything correct, by the book, everything, proper. And the adjuster is delaying and delaying and delaying. And for one reason or another, there was one adjuster who's waiting on one medical note from one shoulder surgeon over a telemedicine. And we were very frustrated for this client because she deserves to receive her benefits. It's been about 7 months since the accident. And finally, things came undone, and the adjuster kind of overnight started paying so many bills, and we just started receiving benefits for this client. So we knew with patience, chances are it's going to, work out. But it's with car accident, it takes very, very long. I know with workman's compensation cases, it does not take this long for an adjuster to investigate.
Right. They're supposed to either dispute the case or pay the case within 2 weeks. Now, as a practical matter, it often will take longer than 2 weeks. And sometimes the claims adjusters will file a notice of dispute and dispute the claim. And as a reason for disputing it, they'll say that the case is under investigation, which I think is kind of fishy, but that just gives them a little more time to get the information they need. But it's unusual for a case not to be disputed or paid, certainly within a month of the claim.
Okay. So that means that in workman's compensation, claims get open much faster. In theory, an adjuster should have only 2 weeks. In practice, sometimes it takes longer. So a client coming to you or an injured worker coming to you a month after the injury or a month and a half is not too soon, because that's plenty of time in the world of workman's compensation for the adjuster to do what they need to do. And if they're not, then you know that there is something serious. So maybe you will file a lawsuit right away, correct?
Right, Joumana. And I know that you see this in car accident cases as well. There is a wide range amongst adjusters of competence. There are some who should not be doing that job, and there are some who are very good at their job.
Correct. By the way, on another forum, I was asked a couple of days ago about someone who had a work-related injury about, if I remember, a year and a half ago. And I said to them, I don't know if you still have time to report this injury because it's been more than a year. I know in car accidents, a car insurance company should be put on notice within 1 year of the accident. But you said to me it's a little bit different in workman's compensation. There is technically and there is practically.
Right. So technically, workers' compensation does not have a statute of limitations, and you know, a statute of limitations in circuit court means if you don't if you don't file a complaint within the prescribed period of time, your case is dead forever, and you can
Right.
never make it. Workers' comp doesn't technically have that. We do have a 2-year back rule. You can never get benefits more than 2 years in the past for once you make your claim. And the you're supposed to make notice and claim in 90 days, but that even is a little wishy because you can give claim and notice verbally. Hey, boss, I got hurt. I need workers' comp. And as a practical matter, how are they ever going to prove you didn't say that? And also, for the defense to raise that defense that you didn't make claim, they have to show that they're actually hurt by it. So somehow, maybe if a witness has died and they're not able to properly investigate the case, they could argue that you waited too long and therefore the claim provision should prevail.
Okay. So in theory, in work-related injuries, you as the injured worker need to make a claim with your employer, whether it's oral or written, with the workman's compensation insurance, whether it's oral or written, within 90 days from when you had the injury. But unless the the insurance for the workman's comp proves, such as with the lady who reached out and said it's been a year and a half, unless they can prove that her employer was harmed by the delay in reporting the claim a year and a half, then it will be okay.
Right, and it's not unusual for someone to learn that they have a workers' compensation case from their doctor. They may have symptoms that they don't think much of, and then when they show up for their yearly checkup, their doctor has a finding that is definitely work related and informs them of this, and that's when they make their claim. They don't know that they have a work injury until their doctor tells them so.
So let's use the example of someone who's exposed to toxic fumes, for example, on the job, and they start having symptoms, and in their mind they're not relating it to what they're being exposed to until they go see a doctor, and the doctor puts two and two together. um, they're making their claim when the doctor finds out, but maybe they've been exposed for 2 years, right? Or
Exactly.
3 or 4.
Exactly. That's fairly common.
So the 90 days, are they from when the doctor tells them and they make the claim, or are they from the first exposure to the job?
I would argue it's from when you know that you have a work-related condition or when you should know. And that's going to be doctrine that you hear a lot with statute of limitations arguments as well.
Okay. And very briefly, you said once an injured worker makes a claim, they can, there is a 2-year statute of limitation. So if I make my claim today, um, my workman's compensation insurance will only pay my medical bills and other benefits going back 2 years from today.
From the day that you make your claim, exactly. So don't call it a statute of limitations. It's a 2-year back rule is what it's called.
Okay. However, you agree with me that most of the time people make claims when they're injured. This is mostly about injuries that you don't even know are related to your job.
That's right. Years ago, there was a lot of asbestos litigation, for instance. And as you know, there's a latency period with that disease that might be a decade later before symptoms show up.
Okay. Now I understand it better. Okay. However, we're not advising anybody to wait even 90 days to make a claim. Make it, as soon as you feel something, because you don't want too many questions about, did this happen now and did this happen on the job and so forth. Once the adjuster is notified that an injured worker is injured, either from the employer or from the injured worker herself or himself, then the adjuster, you said, will investigate. And you said that oftentimes, they definitely will, you said, take a statement from the employer and sometimes from the injured worker, correct?
Yeah, that's right. And that's where I think it comes into play, which we discussed earlier, that if the employer is sympathetic to the employee, that statement that they get will definitely help their case.
Okay. Sometimes adjusters take time to investigate in workman's comp because one of the things they're looking at is that the injury, I mean, insurance companies don't want to pay. So they're looking for a reason not to pay, including workman's compensation insurance companies. So they're looking to see if the injury happened on the job. They're looking to see if this injury existed before and is a pre existing condition, so to speak, right?
That's right. They need to look through your past medical records. Um, a lot of clients don't understand that they need to open up their past medical records when they make the claim.
Right. Anytime you make a demand for your pain and suffering or for payment of your medical records, you are putting your medical condition at issue. And so you cannot say, I will not give you this, but pay for that, because they have the right, every insurance company, whether it's auto or workman's comp, to see what was before and to see what is new or what is aggravated by this work-related injury or by this accident. Sometimes the adjuster or the employer will say, fine, the worker is hurt, but there is no reason why they can't do their job despite the injury.
That's right. You have to prove disability and relationship to work.
Okay. But we agreed that in about a month or so from when a claim is open, an adjuster will either approve the case or dispute the case. If an adjuster disputes the case, what do you do next?
Well, we filed a workers' comp petition in Lansing, or the application I called it in Lansing, and that'll generate a notice of hearing and start you on the path towards litigating that issue.
So in workman's comp, you do not file a complaint with the Workmen's Compensation Tribunal. That's not how you do it.
It's not a complaint; it's an application for hearing.
Okay. It starts with the state of Michigan in Lansing, and then they
Right.
will send it to one, let's say here in our area, there are two workmen's compensation tribunals. One, the ones that you say will open, God willing, effective July 12th, one located in Detroit and one located in Pontiac.
That's exactly right. Years and years ago, there were workers' compensation agencies all over the state. There was one in Ann Arbor, there was one in Port Huron. Um, Now in the metro area, it's just Pontiac and Detroit.
And the injured worker or his lawyer do not get to choose. They get assigned depending on where the injured worker lives or where the injured worker was injured, or how does that work?
It is where the injury occurred. So based on the county where the injury occurred is where it'll be sent to for a hearing.
Okay. And so the state of Michigan will notify the Workmen's Compensation Bureau closest to where the injury happened, or in the county where the injury happened. Oakland County, Pontiac, if it happened in Oakland County, and Detroit, if it happened in Wake County. What about Macomb County, out of curiosity?
Macomb goes to Detroit.
Okay, Macomb goes to Detroit. Now it's in the hand of a judge, a workman's compensation judge. They're called workman's compensation magistrates, right?
That's exactly right. They're appointed by the governor, and they serve a term.
Okay. And now it becomes what you call a case, and the judge or the magistrate starts issuing these control dates, and the case proceeds.
Right. And we probably don't have time in today's show to talk about how a case ends, but all those control dates are preparation for the ending of the case one way or the other. Either it's going to go to trial or it's going to settle, which is called a redemption in workers' comp.
Okay, so redemption is settling.
That's right.
Okay, very good. I think we are coming to the very end of our show. Rami, how much time do we have? 2 minutes?
نعم جمانة 2 minutes.
Okay. This was an amazing show. It always is, but you gave a lot of, wonderful advice. And again, our word of advice to everyone who's listening, who employs people. You may be a very small employer and still be required to buy workman's compensation insurance. And if you do, it is a sword and a shield, because it shields you from being sued personally. And if you don't, just to save a little bit of money, you open yourself up to being sued by your worker, not just for her and his medical bills, her and his wages, but if the injury is the result of your mistake as an employer, then you will also be sued for the injured worker's pain and suffering. And guess what? There will be no insurance to cover you, and it will come out of your pocket as an employer. If you shield yourself by buying workman's compensation insurance, your employer can never sue you for pain and suffering because there is no pain and suffering in workman's compensation. The workman's compensation will only pay, even if it's your fault as an employer, will only pay a person's medical bills and wages. Thank you so much, Pat. Thank you to all of our listeners. Rami, thank you so much.